Yikes. 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 Hi there, my name's Leeja. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. Today we're gonna be reacting to a Sarian video. Yes, you guys loved this when I did it last time. We're gonna do it again because I'm just trying to give the people what they want. Also, we love Bailey here, so like, duh, makes sense. Let's do it.
Hi friends, how are you today?
Hi Bailey. We're gonna react to Sarian's JODI ARIAS video. Yes, highly controversial character. My point in doing this is not to critique Bailey, it is simply to fill in the legal holes. Fill in the holes where maybe a little legal analysis might be helpful for you, her fans, and me, her fan. All right, so that's what we're doing today. Let me take a brief pause and thank the sponsor of today's video, me. That's right, announcing the launch of my consulting services. Yes, if you haven't heard, I am offering sessions with me for two different types of people: law students, content creators, okay? Listen up. If you're a law student or prospective law student, you wanna figure out if law is right for you, if you want to go into that career field, what different types of careers could open up for you, what law school is like. If you wanna hear from someone who's been through it all, that's me. Or if you are a content creator or a prospective content creator and you are interested in starting a YouTube channel but you just don't know where to start, or maybe you started one but you're trying to figure out why it's not growing and you want someone to take a look, give some outside perspective on areas for improvement, areas for potential growth on your channel. Or if you're a content creator and you're starting to get brand deals and you want help with drafting contracts, or if your content has been stolen or used without your permission, or you have other copyright related questions, I'm your gal. Book a session with me today. It's super easy. You just go onto my website, link is in the description down below, and you can see my calendar and you just pick out a session and book it right online. Super easy. All right, I can't wait to work with you. Let's get on with the video. The tale of JODI ARIAS I don't think will ever go out of style because she did it in February and she got like 8 million views on this video. So people clearly are still interested in the tale of JODI ARIAS. So let's learn from Bailey about this sordid crime. Reminder that I may be a lawyer, but I'm not your lawyer, and nothing that I say should ever be construed as legal advice. You should always seek the advice of a licensed attorney before making any legal decisions. Okay, let's get on with it.
So first we're going to start with Travis Alexander. So Travis was born July 29th, 1977.
Ooh, he's a Leo.
So then Travis got a job with Prepaid Legal Services, which was a multi-level marketing company now known as Legal Shield.
Okay, wait. What is this place? Prepaid Legal Services, also known as Legal Shield. Let's look this company up. Revolutionizing access to legal services. With no hourly fee or retainer, we help you worry less and live more. What are you waiting for? Join now and speak with a lawyer in as little as 4 hours after initial contact. Wow, that is... I mean, listen, in theory that sounds great. In theory that goes with like everything I believe in, which is like greater access to legal services. This makes it in your palm. I dig the idea of making lawyers more accessible. That's like the whole ethos behind this channel. So they have plans. You can pay $30 a month. You can get legal advice on an unlimited number of personal legal issues. Like, who needs legal advice every month that much? I feel like you'd be better off just paying a retainer and then you're paying like the same amount, but then you actually just use them when you need them and then they charge you what time they use. Like, what individual has so many legal questions that they need a lawyer on hand at all times, you know? I don't know. Become an associate. Get ready to be your own boss. Okay, so it looks like their associates are the ones that like make sales. It is very odd to have like selling memberships be a whole job. Like, if you're offering memberships that people actually want, you probably shouldn't have to like hire someone to sell the memberships, you know? I am shocked that this is legit from like a legal ethics, professional ethics standpoint. But I guess this way they're able to have non-lawyers push the services of lawyers, so then they're not bound by those professional ethics. I don't know. Sketchy. Okay, so if you wanted to be a lawyer, join Lawyer Network. You can get new clients without any marketing effort or expense. All you have to do is fill out the application. 2 years of experience as a licensed lawyer, malpractice insurance, no disciplinary actions against you. Okay, like that's legit. You have to have some experience and you have to have malpractice insurance. All of our legal plans include a 25% discount off standard hourly rates when you apply, you let us know your standard hourly rate and then offer referred members the same 25%. Okay, so if you're a lawyer in this network, you have to offer clients 25% off. It doesn't cost you anything, but like there's no guarantee that you're being referred, and they get the money. They get the $30 a month or whatever that the member is paying, and you just charge less because they're supposedly referring clients to you. As someone who owns a small firm, I get how this could be a really enticing thing to be like, oh great, like this can be a great marketing tactic for me because these people are just gonna refer me clients as needed. I don't like it. It's basically creating a middleman between lawyers and clients for a fee. Like they're not actually really pro access to legal services. They're pro like accessing legal services through them. What a wild concept for a business. Huh. I'm looking at their Wikipedia page, so like, you know, take it with a grain of salt, but it says the company was founded by Harland Stonecipher in Ada, Oklahoma in 1972, and it was originally known as the Sportsman's Motor Club. That's wild. You're basically becoming affiliated with this organization that charges people to do advertising for the lawyers. You know what I mean? I don't like it. I don't like it one bit. All right, moving on.
Now, at the age of 29, Travis was pretty successful. He was good looking, he had a lot of friends, he loved making people laugh, and was known to be quite a flirt.
That makes sense. That's some Leo behavior.
So Jodi was born July 9th, 1980 in Salinas, California.
Ooh, a Cancer. Moody, dramatic.
Her dad said that Jodi was very verbally abusive towards her mother, but was the kind of person that never took responsibility for her actions. There seemed to be like some kind of tension going on between Jodi and her parents. She was hard to understand, but they seemed like they tried their best to raise her.
I mean, listen, this is why you shouldn't have kids. I'm just saying, like, you never know what they're gonna turn out like. You carry a baby for 9 months, perfect figure, decimated, and then you put in all this time and effort trying to raise them, and they still might turn out to be pricks or murderers. Not for me.
Everyone who was around them said that there was an instant connection between Jodi and Travis. They just really hit it off. So the whole dinner, the two, they talked and they got to know one another. Travis seemed smitten. Friends and coworkers were excited because Travis had been single for a long time and everybody was just really rooting for him to find the one. Anyway, so that night, Jodi and Travis, they stayed up until 4 in the morning just talking about life, religion, and everything. So the next day, Travis was telling coworkers and friends that he wanted to spend the rest of his life with her and that Jodi was just perfect.
The next day he was saying that? Yikes.
So over the course of their relationship, they exchanged 82,000 emails.
That's so many emails. Some sad schmuck, the lowest rung of the prosecutor's office and of that defense attorney's office, had to sift through all whatever 82,000 of those emails to find ones that were actually useful to the case. Having been that sad schmuck before, my God, do I feel for them. Though sometimes it's fun because you're like trying to search for clues, but mostly it's not because you're sitting there sifting through tens of thousands of emails. Yikes.
Jodi would follow him everywhere. Rarely was he seen alone if she was around. Travis would be on his phone and Jodi would be like, who are you talking to? What are you talking about? She would check his phone. She would check his emails. She would hack his MySpace. Travis's friends, they sat him down and they were like, hey, we're worried about you, bud. Jodi is very possessive of you and we're just worried that she's gonna hurt you.
Anyone ever seen The Wheel of Power and Control? Check it out. There's a lot of dings. There's a lot of dings happening.
You're probably wondering how she saw like another girl there and stuff. Well, you best believe Jodi's looking through the windows like just a full-blown creep. She would keep showing up to his house unannounced. She knew the lock codes. Beep, bop, boop, boop, boop. Get right in, okay? She would even break into his house through his doggy door. Yeah.
You know, this isn't legal advice, but pretty sure those are crimes. Can I just say, I've already watched the opening arguments for this case in preparation of this react video, and they should have hired Bailey to do the opening arguments, because they were trash. This prosecutor, trash.
This love, well, she rewarded that love for Travis Victor Alexander by sticking a knife in his chest. And you know, he was a good man, according to her. And with regard to being a good man, well, she slit his throat as a reward for being a good man. And in terms of these blessings, well, she knocked the blessings out of him by putting a bullet in his head.
Listening to his opening arguments was like listening to a science teacher try to tell a story. No offense to science teachers, but the ones that I've had, really dry.
By February of 2007, they became sort of an item. They agreed to just continue dating each other, just to see each other and not anybody else. And as part of that, one of the things that happened is that they both did what is not expected, but what usually can be expected to happen between two young people. They began to engage in sexual relations. And obviously that is against the Mormon faith. And it provided conflict for both of them, that here they were sinning, if you will, all the time, whenever they would get together, and yet professing to be good Mormons on the other hand.
His opening statements were just like one long kind of rambling series of events. He didn't really use any aids, like a timeline or anything to like help the jury out. Didn't do even nearly a good enough job as Bailey is doing in making me feel negatively towards Jodi. You know what I mean? Storytelling, it's a huge skill. Bailey freaking has it. Sorry, but can you imagine Bailey in a court of law looking and acting like her, talking to the jury? I mean, I loved Bailey within 5 seconds of the first video I ever saw of her, so I think it would work really well. But man, talk about subverting the lawyer stereotypes. Petition to get Bailey Sarian barred. Like barred as a lawyer, not like barred from something. You know what I mean? Bailey Sarian, JD. Someone make it happen.
On the stand, Jodi's crying, saying that Travis was controlling and abusive towards her. They asked, "Did you kill Travis?" And she says, yes, but that she did it because she was protecting herself. Jodi said that she blacked out. Okay, she blacked out. She blacked out. She doesn't remember shooting him, dragging him, cutting his neck. No, she doesn't remember any of that. The next thing that she remembered was driving through the desert. So Jodi's new defense was that Travis was beating her and that he was a pedophile. Like the lowest of low. It's so upsetting. It's stories like this that discredit a lot of women who are being abused.
Yikes. I also read that in the defense's argument that she was a survivor of assault and abuse, that they actually had experts come up on the witness stand and like talk about what it's like as a survivor of domestic abuse and how the reason why her attack was so severe and why she reacted so severely to him like lunging at her was because like when you've been through so much abuse, that's like a reasonable reaction and that's a typical reaction of someone who's been abused. Like they really pushed this battered woman narrative really hard. So the counts against Jodi were either premeditated first-degree murder or second-degree murder was their like alternative case. In case the jury didn't find that the murder was premeditated, then they also threw in second-degree murder, which was murder that happened during the course of a burglary. So a lot of times it's called like felony murder, where in the course of committing a felony and a murder happens, then you can be found guilty of murder. But their case in chief was premeditated first-degree murder. So the main thing that they had to show was that it was premeditated because she admitted to killing him on the stand. So like I said, the opening statements for the prosecution, not great. I've seen a lot of litigators do this where they're trying to make the jury sympathetic to their side, but it ends up turning into them sounding really like whiny and accusatory, but like the way that they present it feels like they're exaggerating things. I don't really know how to explain it. I'll show you some clips here.
The defendant couldn't help herself. She was a snoop, just couldn't help herself. And what she did is she went and got a hold of Mr. Alexander's phone, his cellular telephone, and she wanted to see what was in there. Couldn't stop herself from doing that, and so she goes and looks at his cell phone in June of 2007. And she found things there that she didn't like. But it was her going into his cell phone snooping. She did it surreptitiously. She did it without his knowledge because she wanted to know. Just couldn't help herself.
Something weird about the way some litigators talk, where it's like combative, but not in a way that like, it's not, I don't feel like he's like standing up for the victim's rights. It feels like he's just like whining. I found it really unlikable. And like, you really want the jury to be on your side. So anyway, like she said, Jodi's testimony, she claimed self-defense. However, the prosecution had already showed that he had defensive wounds on his hands, like deep cuts where he had tried to block the knife, which doesn't really jive with like him being the aggressor. You know what I mean? stabbing. And then also like the throat slit, like that's not self-defense at that point, you know? But again, they had the expert on to say like, well, maybe that seems like really over the top to you and me, but as a victim of domestic violence, like that wasn't necessarily an out of the question reaction because she had been abused for so long. Usually I say believe women, but I think Bailey's right. This scenario seems unlikely at best. And the jury agreed. They found her guilty and also found that her crime was especially cruel, such that the death penalty was on the table. So once the death penalty is on the table, like you have your main trial, this one lasted 67 days, and then you have another mini trial at sentencing to determine whether she should get life in prison or she should get the death penalty. Also in these states, I've talked about this in other videos where we talk about the death penalty, but the jury has to be what's known as death qualified, meaning they have to ask potential jurors whether or not they'd be willing to give the death penalty should the case require it. So if you're not pro-death penalty, or you're against the death penalty, the likelihood of you being on a jury where the death penalty could be a potential outcome is pretty slim. So basically this mini trial at sentencing is meant to kind of try to build the defense's case that like she is a good person, or like this was a one-time incident, or you know, she came from a bad background, she had past history of abuse, like looking at her character, bringing on experts to talk about her mental state at the time of the crime, things like that, to try to kind of mitigate against the death penalty. That's the defense's role at that point. So at the end of that trial, it ended in a hung jury. The jury was not able to determine one way or the other whether she should get the death penalty or whether she should get life in prison. So then they held a second trial for the sentencing period, and that jury also ended up being hung and not making a determination. So then it went to the judge, because like there's only so much time you can like spend calling juries and bringing in jury after jury after jury to try to get this woman the death penalty, basically, because this wouldn't be happening if the death penalty wasn't on the table. So I think at that point, the judge, having seen multiple juries not be able to give her the death penalty unanimously, probably was like, all right, if we're not able to like 100% say yes, she should get the death penalty, probably shouldn't get the death penalty. That's kind of makes sense at that point. The judge did have the option of giving her life in prison with possibility of parole after 25 years, but the judge instead opted to give her life in prison without the possibility of parole. Okay, so then Jodi appealed her conviction, like Bailey said, and it took forever because like that's how the courts work. Again, the crime happened in 2008. She wasn't convicted until 2015, I think, and then the decision on her appeal wasn't made until March 2020. March 2020, what a month, huh? She made a ton of arguments on appeal as to why the conviction should be overturned. And on appeal, you're not necessarily appealing like, oh, but I didn't do it, like they got the verdict wrong. Instead, you're appealing the process. So you're appealing like something was improper about the trial or about the outcome such that I should get a retrial. That's usually what's on issue at appeal. So she brought a ton of things on appeal, but the two main things she brought were related to the media coverage at the trial, saying that she deserved a new trial because her trial was so unfairly biased and prejudiced by the media frenzy from the trial that she didn't get a fair ruling and that she needed a new trial. And then the second argument was about prosecutorial misconduct, saying that the prosecutor acted so improperly that it prejudiced the outcome of the case, and so she deserves a new trial. I read the court opinion and memorandum, so you don't have to, but if you want to, they're linked below. So regarding the media frenzy, I mean, there's a lot written, but basically, the court notes that prior to the beginning of trial and against the advice of her lawyers, Jodi like voluntarily sought out media coverage, gave interviews, etc., and her own lawyers in court leading up to trial expressed frustration at her like obsession with the PR element of the case because they didn't want her to be giving out interviews because obviously it's going to like potentially prejudice her case or make finding an unbiased jury like nearly impossible. The appellate court also pointed out the pretty extensive procedure that the trial court underwent to make sure that the media coverage was balanced with the fear of any sort of prejudice happening during the case. So like they wanted the media in the courtroom because we do hold this value of like public access to our judicial proceedings. We have that value in this country. So they allowed like court TV to be in the room. And if you want, you can watch the whole trial on court TV. I'll link it down below. I watched the opening arguments, but like there's just hours and hours and hours of footage that they still have available publicly, which is a cool archive to have now that like, you know, she's on appeal and we can go back and we can watch something that happened back in 2015. There is a value to having the media be able to cover court proceedings because it brings it to the public, and like the public wanted it. However, like we don't want the media to be able to bias the jurors or to detract from the proceedings themselves, like as they're unfolding in the courtroom. So the court allowed the cameras to be in the room, but they barred flash photography. They barred the use of the cameras in like the hallways outside of the courtroom. And they required that the jury not look at any sort of media coverage of the case and not like interact with the media at any point during the trial. Despite these rules, there were a number of different media snafus that happened throughout the trial. For example, on at least 2 occasions, media members inadvertently filmed and broadcast some jurors' images. A member of the media attempted to contact a juror as the juror left the courthouse. On at least 1 occasion, the media broadcast Arias's leg restraint, which can have a prejudicial effect, showing her like as, you know, because she was restrained, but she's not yet a convicted criminal. So like leg restraints in the minds of the media and of the public make someone assume someone's already a criminal. You know what I mean? And then juror number 8 was arrested during the course of the trial and excused from service. And then the police disclosed his identifying information to the media during the trial. And then also the defense team received tons of like death threats. The team and like the defense witnesses and stuff were getting threatened. They were getting harassed outside the courtroom via email. Like it was a frenzy. So like I said, even with all of these snafus, the appellate court still has to weigh the value of allowing the public in to see proceedings, and also acknowledge that like in today's day and age, with today's access to media and social media, there's a certain amount of interference or frenzy that is going to happen no matter what, and that is inevitable. And so like to a certain extent, you can't make a full ban of all media in a courtroom because that's not constitutionally valid. So there has to be a certain amount of allowing some of the frenzy in to allow for the public good of having access to the court. And so they say that even though there's this danger of prejudice should the media be allowed in, the counter to that is that she can protect against that prejudice by being able to appeal her conviction up to the appellate court and argue that the media frenzy was in fact prejudicial to her case. There are counter arguments to that where you could say like, okay, but shouldn't someone have that like protection at trial? Like they shouldn't have to go up to the appellate court to get their own constitutional rights, you know? However, it is a really heavy burden for the defendant to prove that the media coverage actually did impede her right to a fair trial. Like that's a really big accusation that then has to be proven at the appellate level. The defendant has to show that there was a carnival-like atmosphere in the courtroom such that it was impossible for the jurors to give an unbiased verdict. Carnival-like is the standard. So the appellate court in the decision, they noted the Supreme Court precedent where carnival-like was found to have occurred. And in those situations, there were times where like the media was like in the box with the defense attorneys, like up front at the front of the courtroom, or they were like interrupting proceedings with questions, or just like milling about during trial and like wandering in and out, like truly carnival-like situation, you know? If we look at the precedent at what is considered carnival-like, this is nowhere near that. Like the decorum within the court itself as the trial was unfolding was still allowed to go on without being interrupted, without it having any sort of actual prejudice against the unfolding of the trial itself. Like this was not a carnival-like atmosphere. Okay, so the court was like, nah, media did not prevent you from having a fair trial. So then JODI argued that there was prosecutorial misconduct during the trial. Okay, so the standard for prosecutorial misconduct in Arizona is as follows. To prevail on a claim of prosecutorial misconduct, a defendant must demonstrate that the prosecutor's misconduct so infected the trial with unfairness as to make the resulting conviction a denial of due process. Okay, so she claimed that the prosecutor used argumentative and aggressive questioning techniques of witnesses, and it was improper, and the court agreed.
He impacted my torso, like
No, I'm not asking where he impacted your torso. I want to know how he was standing.
Because it reminded me of a linebacker, the way he...
I understand that it reminded you of that. What was he doing?
Yes. Finish your answer.
I don't recall like looking in his eyes, seeing his face.
I'm not asking you if you're looking at his eyes. I'm asking you whether or not you could see his face. How could he possibly know to come after you if he's looking down? How is he going to do? Feel his way around?
Objection calls for speculation.
Sustained.
No, do you remember me asking you that?
Yes, I remember.
And do you remember that you said, well, not professional medical care, do you remember that?
I was referring to the splint Travis made for my finger.
I know that that's what you're telling me now, but the line of questioning before involved the shooting. That's what we were talking about, right?
Yes, but then you
And
went to
Mr.
my
Alex-
left finger.
Mr. Alexander was dead after that, wasn't he?
Well, not immediately after that.
No, he grabbed the knife that you stabbed him with, right? So he wasn't dead immediately after that, right?
Objection calls for speculation. She said she hasn't remembered.
The only incident where this could have happened was on June 4th of 2008, right?
Yes.
So this issue of him providing a splint or splinting your finger really doesn't have anything to do with June 4th of 2008, does it?
No.
And you did say that the only injury you received was to your left ring finger on June 4th of 2008, right?
I didn't say that.
Well, yes, you did. And in fact,
No, I
you
didn't.
used the word visible injuries. Do you remember using that term?
Yes, I do.
Argumentative. She said that it's not what she said.
They said that his questioning of Jodi was extremely combative and badgering, and in fact, the defense even moved for a mistrial multiple times during his questioning of witnesses at the trial level. And the judge denied these motions for a mistrial, but admonished the prosecutor regularly for being combative. The appellate court also said, after it became apparent that the prosecutor was not deterred by the court's repeated admonitions and sustained objections, the court should have taken stronger measures to bring the situation under control, including warning the prosecutor that if his improper behavior continued, he would be in contempt of the court's order, and then holding the prosecutor in contempt if he did not comply. So like the appellate court agreed, like yeah, his conduct was improper and the court should have done more. She also argued that he engaged in misconduct because he was giving media interviews and like standing outside the courtroom posing for pictures with people and signing autographs. And the appellate court also agreed, saying his efforts to gain personal notoriety were beneath the office he held as a representative of the state of Arizona in the matter. Those are strong words against a lawyer. She also argued that his conduct in closing arguments was improper, saying that he used evidence improperly. He also told the jurors that she was scamming them and that they would basically be fools to believe her lies.
Instead of a gun, instead of a knife, she uses lies.
Really directly put the jurors' like intelligence and integrity on the line, which obviously is not what the trial was about. He also insinuated that the jurors would be complicit in the murder if they didn't find Jodi guilty, which is like not cool, you know? Like he's putting things at issue that are not on trial.
What she wants you to do is she wants you to carry those gas cans for her. She wants you to help her fill them with gas. That's what she wants you to do, symbolically speaking. What the state is asking you to do is to not leave this courtroom filled with the stench of gasoline on your hands.
And the appellate court was like, yeah, this prosecutor was like definitely acting improperly throughout the trial. Misconduct, left and right. It permeated the trial, they said. The question then becomes, does the cumulative effect of this misconduct justify a retrial? Did it so prejudice the jurors or the trial itself that a retrial is necessary? Did it affect the actual outcome of the case? And the appellate court said no. They said, nonetheless, we conclude that Arias is not entitled to a new trial because there is no reasonable likelihood that the misconduct affected the jury's verdict. That is, the overwhelming evidence of Arias's guilt is as reflected through her own admissions and as clearly set forth within the record, would not have permitted any reasonable juror to acquit her of the charged offense. So basically, like, the record speaks for itself, like she's guilty as hell. And the court says like, okay, so she's definitely guilty and we're not going to overturn her sentence and order a retrial as punishment for this prosecutor's actions, because that's not how he should be punished. Instead, the court's like, hey, Arizona bar, we defer to you to deal with this misconduct. Like this should be referred to you, the Arizona bar, that is like the entity that gives lawyers their licenses, because this was clearly improper and you need to handle it. Yikes. Let me see what his fate was. Yikes, okay? Then in July 2020, the prosecutor agrees to his disbarment. So he was disbarred for the Arias case, but also for conduct not related to the Arias case. It says he was accused of leaking the identity of an Arias juror and sexually harassing female law clerks in his office. Yikes. Juan Martinez. He agreed to give up his license to practice law. Whoa, oh, it gets worse. In the ethics case, I'll link this article that I'm reading down below. In the ethics case, Martinez was accused of leaking the identity of a juror in the Arias case to a blogger with whom he was having a sexual relationship and lying to investigators about it. The ethics complaint also alleged Martinez would stare at the chests of some female employees in the county prosecutor's office and look them up and down as they walked away. It said some female employees would hide in the bathroom, duck into cubicles, or engage in busy work to avoid encountering Martinez. He was a prosecutor for 32 years. There is no way that this ethics violation that he's accused of is the first time that this has happened. How long did this go on for before he actually was held accountable for his actions? I freaking believe it. I mean, any woman who's ever stepped foot in an office, especially like a law office, especially like a prosecutorial office in Arizona, probably has encountered some men like this, where it's like, you're not physically assaulting me, your behavior isn't like outrageously aggressive, so I can't really do anything. You just have become the office creep that every woman in the office tells to avoid. And it just kind of goes on like that. And then he can gain notoriety by becoming the prosecutor that got JODI ARIAS sent to jail. Yikes, I'm worked up. I feel like I should be more worked up about the JODI ARIAS case, but I'm worked up about this frickin' prosecutor. So she then appealed the case again to the Supreme Court of Arizona, and in November of 2020, they declined to review the case. So barring any sort of like federal human rights violations claims that she can make and bring this case before like a federal court, she has pretty much exhausted her appeals options. At this point, it doesn't look like she's getting out of prison. So that's the case of JODI ARIAS. JODI ARIAS? JODI ARIAS? I have said her last name so many different ways during the course of this video. I'm so sorry. What a mess. What a mess. Well, I've linked all the videos down below if you want to like watch opening arguments, if you want to watch JODI's testimony, which spanned like 14 days. There's tons of content. Like I could go on and on and on and on about this case. But this was fascinating. Thank you to Bailey for making, as always, an exceptionally informative video. I hope that I was able to fill in some gaps in her video. Man, oh man. It's rare to find a murder case that's that obvious, I feel. Yikes. Okay, well, again, thank you to the sponsor of today's video, me. Link in the description down below if you want to book a consultation session with me. I look forward to hearing from you and working with you. Also, please consider joining me over on Patreon. Yes, I have a Patreon. We do private live streams over there. I send you like fun photos of my day. I write you little messages. We have a Discord chat where we are constantly talking about stuff, sharing photos of our pets, making friends. It's a really fun time. Please consider joining us. Thank you as always to my multi-platinum patrons, Brett, Piontek, and Anonymous. You know who you are. Thank you so much for your support, and don't forget to join me on Tuesday, Wednesdays, and Saturdays over on Twitch. That's right, I play Sims on Twitch, and also Siberia, which is a little known early 2000s game about a lawyer. We have a fun time, it's chill, we hang out, it's great. Please consider joining me over there. With that being said, thank you so much for watching. If you like this, please consider giving it a thumbs up and hitting that subscribe button if you haven't yet. Comment below if there are any other videos you'd like to see from me. Thank you so much for watching. Have a good day. Goodbye.